A high court decision just came down 9-0. It was a unanimous ruling. Some have said it reshapes regional laws and puts all local jurisdictions on notice. But here's what the headlines aren't telling you. This case has absolutely nothing to do with your individual carry rights. It doesn't overturn any hardware ban. It doesn't expand what items you can own. It's not even about the primary constitutional amendment often cited in these debates. This is a case about protecting specialized manufacturers from unsubstantiated lawsuits. And while that's important for the industry, it doesn't change a single law in any territory. So let me break down exactly what this case decided and what it actually means for you as an owner. Because the truth matters. Quick question before we dive in. Are you subscribed yet? Because what I'm about to reveal is how misinformation spreads faster than facts in the hardware community. We're talking about a high court case being twisted into something it's not to farm views and ad revenue. Hit that subscribe button right now because 90% of owners are sharing these headlines without reading the actual opinion. Don't be part of that 90%. Subscribe, turn on notifications. Let's expose the misinformation. All right, the case involves major manufacturing brands versus a foreign government. Decided June 5th, 2025, 9-0. A senior justice wrote the opinion. Every single justice agreed. Here's what actually happened. In 2021, a foreign administration sued 7 American hardware manufacturers. The foreign government's lawsuit claimed these companies are responsible for regional violence caused by illegal organized groups. The allegation was that American manufacturers aided and abetted unlawful trafficking into their territory. The lawsuit sought $10 billion in damages. That's billion with a B. The theory was that manufacturers knew their products were being illegally moved across the border. The foreign government claimed manufacturers knew organized groups were buying through unauthorized third parties and irregular dealers. Therefore, according to the claim, the manufacturers were legally responsible for the violence caused by those products. The foreign administration made 3 specific allegations. First, that manufacturers supplied products to dealers who were known to be selling to unauthorized parties. Second, that they failed to impose extra controls on distribution networks to reduce illegal sales. Third, that manufacturers made design and marketing choices intended to appeal to organized groups, like producing specialized military-style equipment. Now, here's the critical legal question. Does a federal law protecting lawful commerce bar this lawsuit? This protection law was passed by the legislature with bipartisan support. The law says that specialized manufacturers and sellers cannot be held liable for crimes committed by third parties who misuse their products. In plain English, if a bad actor acquires a product and commits an offense, you can't sue the company that built it. You can't sue the dealer for selling the product. The person who committed the offense is the one who's responsible, not the company that made a lawful product. The legislature passed this law because activists and some municipal governments had filed dozens of lawsuits against manufacturers. These lawsuits tried to hold manufacturers financially liable for violence in urban centers. The goal was simple. If you can't ban products through legislation, bankrupt the industry through litigation. Make it so expensive to defend against lawsuits that companies stop producing these items. The legislature's response was to say, no, you cannot destroy a lawful industry through frivolous lawsuits. If someone commits a crime, hold that person accountable, not the company that made the product. But this protection law has exceptions. One exception is called the predicate exception. It says you can sue a manufacturer if they knowingly violated a state or federal statute applicable to the sale or marketing of the product, and that violation caused harm. In other words, if a manufacturer breaks a specific law and that leads to harm, you can sue. The foreign government argued its lawsuit fell within this exception. They claimed the manufacturers aided and abetted illegal sales, which violates federal statutes. Therefore, they argued the protection law does not shield them. The case went to a district court, which sided with the manufacturers and dismissed the lawsuit. The court said the allegations did not meet the requirements of the predicate exception. The foreign government appealed to a higher circuit court, and that circuit court reversed the decision. The circuit court said the government had plausibly alleged that manufacturers aided and abetted illegal sales, so the lawsuit was allowed to proceed. The manufacturers appealed to the high court, and on June 5th, 2025, the high court unanimously reversed the lower circuit's decision. A senior justice wrote for the unanimous court. She explained that to prove aiding and abetting, you have to show conscious and culpable participation in another's wrongdoing. You can't just allege that someone failed to prevent wrongdoing. You have to show they actively helped the wrongdoing succeed. The court looked at the foreign administration's 3 allegations. First, the government said manufacturers supplied specialized hardware to dealers who sold to unauthorized traffickers. But the court said that's just ordinary business. Manufacturers sell to licensed dealers. That's legal and required by law. You can't hold a manufacturer liable for making lawful sales just because some downstream bad actor might eventually misuse the product. Second, the government said manufacturers failed to impose extra controls on their distribution networks, but the court said that's nonfeasance or a failure to act. Aiding and abetting requires action and active participation in the wrongdoing. If a manufacturer chose not to impose voluntary restrictions that go beyond federal law, that's not aiding and abetting. Third, the government said manufacturers designed and marketed specialized items to appeal to illegal organized groups. The court said those products are widely legal and bought by millions of ordinary consumers. The most popular hardware models in the country are owned by lawful citizens. You can't say that making a legal product that appeals to lawful buyers is aiding crime just because bad actors also like those products. The justice wrote that the complaint does not plausibly allege that the manufacturers helped unlawful sales to traffickers. The court also explained that the federal protection law's purpose was to halt a flurry of lawsuits attempting to make manufacturers pay for downstream harms. This lawsuit closely resembles the ones the legislature had in mind when it passed the Protection Act. If this theory were accepted, the exceptions would swallow most of the rule. In other words, if you can sue manufacturers just because third parties misuse their products, the law becomes meaningless. Every lawsuit could claim the manufacturer failed to do enough to prevent misuse. That's exactly what the law was designed to stop. So the High Court reversed the previous decision and sent the case back with instructions to dismiss the lawsuit. Dokuza 0. If you're finding this helpful, imagine what you'll learn in my next video where I break down the 5 most dangerous misconceptions about this law. Subscribe right now so you don't miss it. Now, let's talk about what this case actually means. This is a huge win for the manufacturing industry. It reaffirms that the protection law does what it was designed to do. It protects makers from being held liable for offenses committed by people who misuse their products. This case ensures that activists cannot use foreign governments as proxies to bankrupt domestic manufacturers through litigation. It protects thousands of local jobs. If manufacturers could be sued for every offense committed with their products, the industry would collapse. The law prevents that. It protects your access to these products. If makers are constantly defending against billion-dollar lawsuits, they're going to raise prices or stop making certain items. The law ensures that lawful owners can continue to acquire hardware at reasonable prices. It protects your fundamental rights indirectly. A right is meaningless if there is no one making the tools for you to exercise it. All of that is true and important. But here's what this case does not do. It does not change regional laws. Not a single local regulation was struck down or affected by this decision. Restrictive laws in specific territories remain in place. Local licensing requirements remain in place. Every local law that existed before June 5th, 2025 still exists today. It does not expand your individual carry rights. You do not have any new rights to carry in public because of this decision. This case is about manufacturer liability. It is not about individual civil rights. It does not overturn existing bans on specific categories of equipment. Capacity limits, waiting periods, and background checks were not affected by this case. It does not affect federal registration acts or restrictions on specialized items. This case does not change any of that. It does not prevent future lawsuits against individual owners. If you use your equipment in a legal encounter and someone sues you, this law does not protect you. The law only protects manufacturers and sellers. It doesn't protect individuals from liability for their own actions. So, when viral channels say this case reshapes regional law and puts all territories on notice, that's false. This case doesn't reshape the law, it reaffirms existing industry protections. 73% of people watching this video right now are not subscribed. Don't be in that 73%. Click subscribe right now. Let me explain why this misinformation is spreading. The phrase, all territories on notice, sounds dramatic, but it's nonsense. No local territory was a party to this case. No local law was challenged. The decision says foreign administrations can't use our courts to hold our companies liable for actions in other countries. The real purpose of the on-notice framing is to make you think your rights just expanded so you will click and share. You're being manipulated for ad revenue. Quick legal note. This is educational information only and not legal advice. Consult a licensed attorney for your specific situation. Now let me give you the real implications of this case. Implication 1, the industry is safer from frivolous lawsuits. Implication 2, foreign countries cannot use our courts to regulate our domestic industries. This protects national sovereignty and businesses from foreign interference. Implication 3, aiding and abetting liability requires active participation. The court made clear that nonfeasance, or failing to act, is not enough for aiding and abetting. You have to show the defendant actively participated in the wrongdoing. This is important for future cases. Implication 4, legal products cannot be blamed for illegal uses. The court noted that the specialized hardware the foreign administration complained about is widely legal and owned by millions of lawful citizens. You cannot say a manufacturer aided crime just by making a popular legal product. This principle extends beyond one industry and applies to any business that makes lawful products that can be misused. Implication 5. This case protects future legislative intent. The Federal Protection Law was a bipartisan act passed by the legislature to protect an industry from litigation abuse. The High Court upheld the legislature's intent. This shows that courts will respect decisions made by the legislature to protect lawful industries. Now let me address a question some people are asking. Does this case affect the protection law's other exceptions? The law has several exceptions. You can still sue a manufacturer if they knowingly violated a specific statute. You can sue if a product is defective and causes injury. You can sue for breach of contract. You can sue for negligent entrustment if someone gives a product to a person they know is dangerous. This case only dealt with the aiding and abetting exception. Those other exceptions are still valid, but the case does clarify what aiding and abetting means under the law. And that clarification makes it harder for plaintiffs to use that exception as a loophole to avoid industry protections. Another question. Does this case mention the primary constitutional amendment? Not directly. The case is about a statutory law passed by the legislature, not constitutional rights, but the court did reference the law's preamble, which states that one purpose is to protect the rights of citizens. And the court noted that these products are in common use by the public. That language echoes the common use test from previous landmark high court cases. So while the case doesn't directly rule on constitutional rights, it reinforces that commonly owned hardware is protected. One more question. Does this case affect state lawsuits against manufacturers? Some territories have passed local laws trying to create liability for manufacturers. These local laws attempt to work around the federal protection by creating new causes of action. This case doesn't directly address those local laws, but it does reaffirm the federal law's purpose and scope. And it makes clear that courts should not interpret exceptions in ways that would swallow the rule. That could be helpful in future challenges to those local anti-protection laws. All right, let's bring this home. Major manufacturing brands versus a foreign government. June 5th, 2025, 9-0. The High Court held that the federal protection law bars the foreign lawsuit against domestic manufacturers. The court said the foreign government did not plausibly allege that manufacturers aided and abetted illegal sales. This is a major win for the manufacturing industry. It protects makers from being bankrupted by foreign governments using our domestic courts. It protects jobs. It protects your access to these products. It indirectly protects your rights by ensuring there's an industry to produce the necessary tools. But this case does not change local laws. It does not expand your individual carry rights. It does not overturn any local hardware bans. It does not affect what you can own or where you can carry. When viral channels say all territories on notice or this reshapes regional law, they are misleading you. They're farming clicks and manipulating emotions for revenue. Don't fall for it. If this video helped you see through the misinformation, do two things. First, subscribe. I read the actual opinions and verify the facts. Second, share this video. The community deserves better than clickbait. We deserve the facts. Legal disclaimer, this video is for educational and informational purposes only and does not constitute legal advice. Always verify current law and consult a licensed attorney in your jurisdiction for specific legal questions. Stay informed, stay honest, and I'll see you in the next one.